I would have thought there'd be more people that needed US visas here. I certainly need one.
Maybe not. Or maybe it's just too late in the day and they're tired. It's not going to work? Okay, that's okay. Don't worry about it. Okay, so I'll just use... So what do we do?
Could we get the doors closed, please? It's a very select crowd for the last session of the day. I'm surprised that so many of you have actually survived the past 2 days of Bitspiration madness. Okay, well, it is my great pleasure to introduce you to Tahmina Watson, who is an immigration attorney and founder of Watson Immigration Law in Seattle. That's in the great state of Washington. She was a practicing barrister in London before immigrating to the United States herself, and she'll be talking about visa options to the US for entrepreneurs. So please, can you give a warm welcome to Thamina? Thank you.
Thank you so much. How's everyone doing? Good day, good day. Well, it's the last session. Thank you so much for hanging on. I really appreciate it. So one of the reasons I'm here is really because I'm a very big proponent of startup visas. We do not have one in the US. I am going to flip around a little bit of what we're going to talk about because we only have half an hour. I'm really going to cover non-immigrant visas, immigrant visas, and then what's happening through changes to immigration law through Obama's executive actions. But really what I'm going to do is talk about the executive actions first. And the other thing I want to say is if you have any questions, jump in right away because half an hour will go by very quickly and questions as they come up, please ask them. I find people forget. So we do not have a startup visa, as I mentioned. And we had a video. I was going to show you a video of what happens when a founder goes to the US, but unfortunately it's not going to work. But I do encourage you to read my book. It just got published in March. It's available on Amazon, on Kindle and other ebook platforms. And I talk about what's wrong with the current system, what the options are, and what the government can do to change things. So we're going to talk about non-immigrant visas first. Non-immigrant means that you are not going to intend to live in the US or work in the US. So the first visa I'm going to talk about is a B1, B2 visa. Let's say you're a startup founder and you have a meeting with a potential VC or an angel investor and you need to go to the US. This is the visa you might be looking at. And unlike other European citizens, unfortunately Polish citizens do not get the ESTA visa waiver. So this is your only option. What is the embassy going to look at when they look at you? They look at whether you intend to live or work in the US. And how do you prove that you're not going to live or work in the US? You have to prove that you're working in your home country. So when you go to the embassy, they want to see ties to your home country. How do you prove ties? You prove ties to your work, pay stubs, contracts of work, whatever you have to prove that you're working. Other things that you can show are assets to your home country. That might be a house, a lease, a mortgage, children, family, etc., etc. Intent is the key word you have to think about when you're looking at a B1, B2 visa. Employment-based visas. Now, these are the critical visas I want you to think about when you are trying to work in the US. The 4 visas that I'm going to talk about are the L1A, and E1, E2. I don't mention E1 there, but it's similar to E2. H1B visa and the O1 visa. We're going to take one at a time. The L1, and there's a lot of information I see, but I'll explain them to you. L1 is when you are transferring between 2 countries for one company. So let's say your startup is now very well established in your home country, and it's Poland at the moment. and you are the founder or a co-founder or a manager of this company. Now you want to transfer to the US, open a company there. The government's going to see that you have been working abroad for at least 1 year out of the last 3 years. How do you prove that? You prove that with tax returns, pay stubs, and so forth. They do want to see that there's a relationship with the two companies. So who are the founders, who are the shareholders of the company abroad, and who are the shareholders of the company in the US? That's how the relationship, the qualifying relationship, is established. The visa is initially given for 1 year, and it can be extended up to 7 years. This visa is a very nice visa to get so that you can piggyback onto a green card application. It's a different application entirely, but it's piggybacking on this type of requirements. The application process is to file a petition with the USCIS, which is the United States Citizenship and Immigration Services, which is in the US. I describe it like this. You have a house. That's your business. The house has a structure, which is the corporation. The house has accessories and furniture, which is the licenses, equipment, and so forth. All of that evidence actually has to be submitted to the USCIS. So they can see that this establishment is ready to run, but for the visa that you will be given. Once the USCIS actually approves the application, the petition is then sent to the local embassy where you'll have an interview. They want to see that you are actually eligible, you don't have any criminal issues or any other issue that will make you inadmissible to the US, and they will give you a visa to come to the US. Any questions on that before we move on? I'm sort of rushing around here. All right, I'm going to move on. The E1, E2 treaty trader and investor visa. This is a very popular one. If you do not have an established company abroad, you can think about an E1, E2 visa. The trick is you have to be from a country that is part of the treaty. Now, India, China, Indonesia, there are some countries that do not fall within the treaty, but Poland is, luckily. The application for this petition is actually made directly at the embassy. If you are in the US for whatever reason, you could potentially change your status to E1, E2. However, if you were to travel at any time, you do need to file afresh to get a visa from the embassy. So more often than not, the suggestion is go to the embassy first time round. Now, this is, in fact, an investment visa. The government doesn't, the law doesn't have a minimum requirement actually is stated, but it says you have to invest a substantial amount. Now, the rule of thumb of how much money you're investing is generally about $100,000. It can be less than that, depending on what your business is. But if anybody will, if you ask any lawyer, they'll say, well, you know, really $100,000. More or less would work, depending on the visa. Why this is good is because it's a relatively small amount of investment compared to some other visas that exist. And once you take your startup to the US, you can actually get investment from other, you know, VCs and so forth. The not so good thing about the E2 is that you have to have at least 51% of the company. Now, if you have co-founders and then you have VCs and angels investing in your company, your shares could possibly dwindle. So your continued eligibility might be in question. So that's something to carefully think about. But once you get to the US on the E1, E2, there might be options to change to a different type of visa category. When you apply for this visa, again, you need to have that house in place. Remember, I said you have to have a house. That's your corporation, the licenses, the equipment, all of those things. And when an application is filed, it actually becomes 3 or 4 inches thick. Now think about a tiny piece of paper. There's a lot of documentation to show. One of the things that's important in this type of visa category is where did your money come from? The government wants to see the source of funds as well as the path of the funds. So that means showing your tax returns, your bank statements, the wire transfers, and so forth. The government also wants to see that you are going to the US to direct and develop the business. Now, what does that mean? Now, the best example I have come up with is really a restaurant. So let's say you've bought a restaurant and you are now going to run that restaurant. That means that you really are operating it. You're not serving the food to the customers. And that's what you have to distinguish in your mind. So when they're looking at the job description, they really want to see that you're really operating it. The E2 is actually a very nice visa because it also, typically restaurants are good ones to explain because you're constantly employing people and you're generating revenue, hopefully. And that's what the government is looking for. So when you go to the embassy, embassies really actually like clients who are getting E1, E2s. So it's a good visa to have. Any questions on this? All right, moving forward. Yes. Oh, very good question. Actually, it can vary between countries, but initially given for 1 year, sometimes even 2 years. It can be maximum of 5, depending on which country you come from. But you can also renew it for as long as the visa is, the business is profitable or active. This visa, you can have it 20 plus years. There are people in America who've had it for many years.
Okay, so let's say that the business was successful, and after 5 years, so I can extend it even for 20, as you said.
That's correct.
But is it possible to go from that stay in US to green card or any other kind of citizenship if the business grew to the substantial size?
That's a very good question. The E2, E1 visa doesn't lead to a green card by itself. Like the L1 had an equivalent sort of green card path. The E1, E2 doesn't have it. However, you can move on to something else that could potentially get you a green card, like a national interest waiver, and I'll come to that in a minute. Or you could use the funds that you've used to invest in the E2, and you could potentially go to something called an EB5. You need to reassess constantly to see what other visa category you can move on to. But great question. Any other questions before we move on? All right, moving on. Oopsie, sorry. I meant to go here. The H-1B visa is the most popular work visa in the United States. The visa begins on the first day of the fiscal year, which is October 1st every year. The actual application date is 6 months in advance of that. So April 1st is when you can file these applications. And I don't know if anyone's familiar with this, but it becomes a lottery. April 1st is really the lawyer's version of the accountant's tax day. You know, we work for weeks and weeks and weeks, like without sleep, because we need to file our applications on those days. The foundational requirements are that you must have a bachelor's degree, and the job must require a bachelor's degree. And what does that mean? If I'm a lawyer, I can't really apply for a doctor's job. But it also means that an example, we filed for an application for a software developer, and that person had a degree in information management. The government's like, show me that an information management degree leads to a software developer job. And to me, I'm a layperson when it comes to technology. To me, it seems like you should easily be a software developer. But the government really looks into whether it's necessary to have that degree. And if there's a mismatch, they will actually not approve the application. The application is done by the employer, not the employee. So if you find a job, you can't file for it, the employer, the company has to do it. The other foundational requirement is there's a minimum pay that must be given for a particular job in a particular area. So a doctor in New York might get $90,000 a year. A doctor in Kansas City might get $60,000 a year. So the employer has to promise that they will pay that minimum prevailing salary to the employee. And that promise is done through the Department of Labor. an application is submitted to the Department of Labor, they will approve it, and then that application is later submitted to the USCIS. Once you're in the lottery, so if you've won the lottery, the government gives out 65,000 visas each year for people with a bachelor's degree, an additional 20,000 visas for people who have a master's degree from a United States school. So once you've won the lottery, and it's 1 in 3 chances, this year the government got 233,000 applications. But once you're in it, you can actually change jobs. So if you're from Microsoft, you can then go to Amazon, and you're not subject to that timeline anymore. The maximum time that you can have an H-1B is 6 years. Initially, it's given for 3 years, and then you can extend it for another 3 years. If you want a green card, the employer can apply for a green card for you. It's a different method altogether, but it has to be done before the 6th year so that you can prolong your stay in the US. In 2010, the government came up with a memo saying that an employer must have control of the employee. And what did they mean by that? They had a very long memo explaining what that meant. It meant that you have to have control. You have to have the ability to hire or fire and supervise this particular employee. And that came out because there was a fraud investigation into employers who were consulting companies. And they were taking these employees and sending them to Microsoft or third-party sites. And the question was, who was really supervising this employee? And as a result of that memo, H-1Bs became relatively more difficult in that you have to show very, very tight contracts. You have to show how is this person being monitored. And whether you're a consulting company or not, you still had to prove these things. Now, fast forward the clock to 2012. As a startup, you really couldn't do a self-employed H-1B before. And even if you did it before, you were doing it almost sort of on the quiet. You weren't really saying, I'm an owner of the company. But in 2012, USCIS came up with a new guidelines, saying if you are a startup and you want to get an H-1B, you can absolutely get it, but you have to show that the company, your company, is actually employing you. So how do you do that? You can't be, remember, we have all these requirements about job has to match the background and so forth. So you really can't be a CEO if you are going to get an H-1B. You can be a CEO if you are getting an E-2, but you cannot be a CEO of a company if you're getting H-1B. So you have to look at your background. If you're an engineer, you're going to be the director of engineering, for example, and that's how you're going to be applying for this H-1B. But then self-employed, now there's an additional layer on this application. And the government's guidance was that if you are self-employed, that house I mentioned, the corporation, also is necessary for this type of application. But the government said, we want to see the board of directors are actually going to be governing you. They can hire, fire, and supervise you. But what I found in my practice, there are other methods of doing that. You might have co-founders, you might have more than one co-founder, in which case you might have a third of the shares of the company. And if that's the case, the other two people could perhaps control your work. So that's one method of doing it. What if you're 50-50 shareholders in this company? Well, then you have equal control. So how do you show that somebody else is going to control you? So what we tried, and successfully tried, was to give up voting shares. There are practical implications, and really it's not ideal, but you really need to get this company up and running. So giving up voting rights was one way of succeeding in these applications. Self-employed H-1Bs are good to have because you have a long, ride, if you like, 6 years in this process. But they are very difficult. And one story I will tell you is last year we filed an H-1B for somebody who was a student and then getting into this lottery. And when the government came up with this self-employed guidance, they said, you know, these are the rules, you can do this. But one of the foundational rules of the H-1B is the employer has to pay for all the fees in the H-1B. So when we filed this application for my client, the client gave me employer checks, the company checks. What we didn't notice at the time is he signed the checks. So when the government sent back the application about 6 weeks later, we saw that they rejected it because of the signature being by the client. Now, initially we were thinking, gosh, why did he sign the check? And he said, well, I'm the one who opened the account. I'm self-employed. So then we were thinking, what do we do? How do we get this case back into the pool? So it was a long fight. We had to throw back the policy that the government had at them, saying, look, you said self-employment is allowed, and if this self-employed person has a bank account that only they could open and only they could sign, then how else are you going to allow a sole proprietor to get an H-1B? So we were able to successfully get that application in, and I tell you, it took about 9 months. Wasn't fun. And then once we got that in, then we had the question of employer-employee relationship. So we had to then send all the investment documents, the cap tables, the shares, the voting agreements, and all of those things. Eventually we won it. It took over a year to win this case, and it's totally possible, but it's not easy. So that's a victory. Any questions on the H-1Bs before we move on? All right. Other visa options, hang on, I'm going to go to, I didn't talk about O visas. The O visa, it's somewhere there in my slides, but I'll just go over it. Now, let's say you are a fantastic startup. You have raised funds in Poland, you've raised funds in the US, you have been written up in magazines, your name is splashed everywhere. You're essentially famous. Now, the O visa is for, essentially, another name of it is Genius Visa. They're looking at Nobel Prize winners, Oscar winners, and so forth, but it doesn't mean that you couldn't get it. You just need to be able to prove the requirements. And how do you prove it? There are 8 requirements. If you can meet 3 of them, in the olden days, 3 would have done it. But nowadays, you meet 3 and then you have to say, yes, I'm still great. But what are those requirements? You have to show that you have made an original scientific or a significant contribution to your industry. You have been named in publications. So are you Beckham? Are you Beckham, and have you been written about in newspapers? Have you commanded a very high salary? Have you been a critical part of an organization which led to their success? So some of these requirements, if you can prove 3 of them, and then you have to do what's called a merits argument, saying, well, yes, I've done all of these 3 things, and actually you try to, it's like trying to shoot at a dart. You know, you want to shoot as many and get bullseye, but you don't know which one is going to hit bullseye. So then the government will say, well, show me how many newspapers are circulated. So you've been published in People magazine. So People magazine, how many of those circulated? So then we create a spreadsheet of the times, you know, the publication is, you know, 100,000 each month, and what's a geographical distribution. And these days with blogging and, you know, the internet, that sort of spreadsheet takes a different sort of turn. But the O visa is a very nice visa if you have raised a lot of money and you've created a lot of jobs. And the government in the US is really looking for jobs and revenue creation. And the O visa also allows a piggyback of a green card application, similar to the L1 that I mentioned. So, and I'm going to come back to that in a minute, but it's a nice visa to use as a stepping stone. I mentioned H3 and J1. These are training visas. So let's say you are going to be part of an accelerator, and you're going to be there for 3 or 4 months. And the B1, B2 doesn't really do it for you. You've been rejected. You could try a J1 visa. That's done through the Department of State. So a lawyer like me wouldn't typically apply for that. The employer would go through the Department of State, get a J visa for you. You'd use that visa to go into the country, do your accelerator program, and come back. And hopefully use that time to make connections and try to find another visa category. But the J1 may or may not work for you. So then what can you do? There's something called an H3 visa, which is essentially a training visa where the employer will show this is how we're training them. So you're creating a schedule. The schedule will be textbook training, hands-on training, as well as examination. The H3 visa can be for initially for 1 year, and it can be extended for another year, a total of 2 years. If you maximize that time in the US, you have to go back to your home country for 6 months before you can come back to the US. We have used H3 visas as a bridging the gap process. So let's say there are no H1Bs left in this fiscal year, and there's a suitable position for an H3 where the employer says, yes, I'll try it. It's really to bridge the gap so that you're on the H3 and then we can piggyback onto the H1B. So then the green card application. So these are the immigrant visa petitions. Any questions on the non-immigrant before I move on? Okay. So I say PERM there, the long hand for that is permanent labor certification. And this is where the government has to prove that they have done, that the employer has to prove to the government they have done everything in their power to find an American worker to fill that position. Now, how do they do that? They have to prove by advertising in a Sunday newspaper 2 Sundays in a row. They have to advertise in industry journals. So if you're an engineer, maybe there's an engineer magazine. If you're a doctor, there's a doctor magazine. You have to advertise in an industry journal. You have to advertise for 30 days in total, and then wait around for 30 days so that you can prove to the government people have applied for this job. Now, if people have applied for this job, you have to make a good faith effort to recruit. So there has to be very good record keeping of who applied, why you rejected them. And you have to keep very good file of all of these applicants. Because once you file with the Department of Labor, that's where it's done, they could potentially audit the case. And they will say, show me which newspaper you advertised in. Show me which magazine you advertised in. Show me which applicants applied and why you rejected them. Only then will the Department of Labor approve the application saying, yes, I'm satisfied. You tried to find an American worker and you couldn't. Now, the process is that you file an I-140. This is the name of a form. I'm not going to bore you with that too much. And this could be pending for a very, very long time. Partly why we need immigration reform in the United States is because the system is broken. People from India, China, Philippines, and Mexico have to be in this waiting line for a very long time. So once this form is filed, they're just waiting around. When their time is current, meaning there's a monthly bulletin, which comes up with dates every month about, applications that were filed in 2002 on such and such date can now get a green card. You're looking for that date. And that's when you can file an actual green card application. So I mentioned to you that if you're a startup, there's the H1B, you can be self-employed. Now, when you're self-employed, you can't do this permanent labor certification process because you have to advertise this job that is really yours. So nobody's ever going to believe that you have made a good faith effort to find a replacement for yourself. So it's simply not possible. The forms will ask, do you have any ownership? Does any family member own this company? And all of those reasons will get you rejected from this process. So then they came up with national interest waiver for entrepreneurs. This policy was instituted in 2011 for entrepreneurs, but the actual petition, this type of application exists for many, many years. They just allowed entrepreneurs to use it. The reason it's called national interest waiver is because you're waiving the recruitment in the interest of the nation. So basically, if you're an entrepreneur, and from the E2, you could potentially go to this. The EB1 is when you are the O visa piggybacking onto the same requirements for a green card. The EB1C is when you have the L1, the multinational transfer, and you're piggybacking onto a green card for that. If you have lots and lots of money, you can invest $500,000 minimum and you will get a green card immediately. When you hear in the news rich man's visa or you're buying a green card, that's what the EB5 is. It's not really for the typical startup founder, but I put it in there just so you have it for completion's sake. Now, very quickly, I'm going to tell you about...
Could you swipe back?
Yes.
So technically, I didn't get that part. Could you repeat?
Okay, so this is really going straight to a green card, and this is an investment visa. In a poor area, you can invest $500,000. If it's not a poor area, you can invest $1 million, and you and your entire family, children under 21, everyone will get a green card. It's conditional, meaning that you have to create 10 jobs in 2 years. Once 2 years have gone by, you show those 10 jobs with payroll documents and so forth. I'm going to move on very quickly to what's happening with the Obama's immigration changes, because we don't have much time. Immigration reform is really essential in the US. Part of that is also the startup visa. We don't have it yet, and who knows when we'll get it. We have to wait for the next presidential election to see if we get any real reform. But in the meantime, Obama really has tried to make some tweaks and changes. And I would very much encourage everybody to sign up to my blog and Twitter handle to make sure that you are keeping abreast of what's going on, because these are real changes coming soon. For entrepreneurs, Obama is going to use existing law called parole, saying if you are a researcher, founder, or an entrepreneur, you can get this parole because you are going to help significant public benefit of the US. You will have to show that you've raised some money and you've got some money in the bank to take care of yourself. We don't know what those terms are. They're being discussed as we speak. In fact, tomorrow, the government is going to have a teleconference with the public to seek ideas. Unfortunately, I'm not there, so I don't know what's going to happen in that teleconference, but I'm hoping for the best, and I hope by the end of the year we'll have some real rules. The other thing that Obama did was H-1B visa holder spouses could not traditionally work in the US, but then since May 26, 2015, certain H-4 visa holders are able to work. The other executive action item that's going to be changed is, remember I said you're waiting in a line forever to get a green card? Well, Obama's going to allow the green card application to be filed sooner rather than later. You'll get a work permit, you just won't get a green card until your number is up. So these are some of the changes that are going to make some very significant difference to people's lives in the US. I would very much encourage people to keep an eye on the entrepreneurial parole, because that will be the alternative to the startup visa. It's not going to be a visa, but it will allow people to go to the US. And anybody who's really in the ecosystem of startups in Poland, you should keep an eye on this. My blog, my email, Twitter, you know, like us on Facebook, look at my book, Amazon. That's all I have for you to hear from me.
Tahmina Watson, many thanks. It's been great having you here.
Thank you.
Round of applause, please.
Thank you so much.